Hello everyone and welcome to this new Privacy Rules webcast episode. My name is Alessandro Di Mattia, Legal and Executive Assistant at Privacy Rules. And today I'm joined by our expert from the firm Rowan Legal, representing Czech Republic and Slovakia for Privacy Rules. And in particular, I'm with their expert Michal Nulíček and Jan Tomíšek, that I'm pleased to introduce to you. So without further delay, I would like to turn it over to them and to ask them to speak a bit about themselves and their experience in Rowan Legal.
Hello everyone, and thank you for the intro, and also thank you for the opportunity to join Privacy Rules, obviously. I will perhaps start with a few words about our firm. Basically, we are one of the three largest independent law firms in the Czech Republic and Slovakia. We have three offices in Prague, Brno, and Bratislava. And basically, IT, data protection, and sort of digital issues have been one of the core practices of our firm from the early 1990s. We have a team of approximately 15 lawyers and paralegals that deal with IT and data protection issues daily. A lot of them combine legal education, economic education, they are ex-programmers and so on, so there's a technical overlap. We are also members of the IAPP and have 4 certified IAPP lawyers, including the two of us, which brings me to Jan, who is our managing associate from the Brno office, a very bright guy that is the one that has the 3 degrees, law, economics, and IT, an ex-programmer that deals with IT, data protection, and anything digital, basically, on a daily basis.
Okay, and let me briefly introduce Michal. Michal joined Rowan Legal in 2014, and before that he worked as a senior lawyer for Hogan Lovells for their Prague office, so he has a long track record advising international clients on data protection matters here in Czech Republic and Slovakia.
Perfect, Michal. Perfect, Jan. Thank you very much for this brief introduction. Just a quick question. After 2 years from the implementation of the GDPR, what's the current stage in Slovakia and Czech Republic?
Firstly, the Czech authority is quite active. It is one of the most active authorities in terms of a number of controls that it has conducted from all the EU authorities. Albeit the maximum level of fine is not comparable to those imposed in France and other countries, to the big technology giants. The maximum fine is in the range of tens of thousands of euros. But as I said, it's a very active one. In practice, the way they approach the control is typically, they would send you a letter about initiation of the control. And the company would have only a couple of days, perhaps 5 to 10 days, to submit documents and information responding to a very long list of requirements of the office. So it really, the companies must be ready for that control, and the office, and that should be added, is not hesitant to conduct mystery shopping, to physically inspect IT systems and so on. So the level of preparation for such control must be quite high.
Yeah, and the same is valid for Slovakia. Maybe one specific is that the Slovakian authority is not hesitant to bring in an external expert, for example, for information security. So if they announce they will inspect your information systems, you should be ready for the authority bringing someone who is really in the know regarding IT security, so that the audit or the inspection will probably not be superficial, but go in quite a depth.
And perhaps one thing that we should add regarding the general data protection regime or the practice in the Czech Republic, we have even a pre-GDPR successful private enforcement case, which caught some attention in the Czech Republic, obviously there are companies that sort of caught this opportunity and now are inviting data subjects that are affected by the various data breaches to sue the relevant controllers. It's not something huge in the Czech Republic yet, but with the collective actions coming, we believe that will be a hot topic in the Czech Republic.
Oh, that's interesting. Thank you, Jan. Thank you, Michal. And I have just one last question, and I would like to know if there is or if there are any trending or interesting topics that you would like to discuss in relation to this sector in Czech Republic and Slovakia.
Absolutely. There are. I would just perhaps start by following up on what we said about the Czech authority. One of the issues with the authority is that it's not, albeit it's very active in the enforcement area, it's not as active in publishing guidances and so on and so forth. So some of the decisions that they issue are quite surprising and sometimes also heavily impact the business of the clients. And the two areas which we would like to talk about now are I would say, the two where you can see this approach of the office in practice. The first one is biometric signatures. That's basically a technology that a bank or an insurance company or utility company would use for electronic signing of contracts. So it's where you sign a contract electronically on a device, a sign pad typically, that records biometric data, such as the pressure, the speed of the signature, and so on. This technology was widely implemented by, I would say, majority of the large corporations, B2C corporations in the Czech Republic during the last 10 years. The office did not raise too many objections to that. It hasn't really publicly commented too much. But recently, this year, they have issued a decision basically declaring this technology as illegal on the basis that the office believes that it's not necessary, that the collection of biometric data is not necessary for signing a contract. That was a big surprise. Now, obviously, companies are looking into whether it's completely illegal, whether there's a way to legally implement this technology. We believe there is. It obviously depends on the precise sort of purpose and the way the technology is implemented, but it's definitely something foreign companies should be looking into if they have daughters in the Czech company that use this technology.
Exactly. The issue in question is whether this individual decision is also applicable on other cases, other implementations in other companies, and the office hasn't been clear on this very much since the decision. So everybody is a bit nervous. And similar is the situation for marketing consents, specifically consents for direct mailing. The authority has had a very outdated guideline, pre-GDPR guideline on its website. And the information in this guideline were quite relaxed, a very relaxed approach on contents of the marketing consent, on the form and mechanism of its collection. And then out of the blue, the authority issued a decision with regard to one of the companies that made marketing part of its business model, and said that you have to collect separate consents for your own marketing communications and third-party marketing communications, that basically these need to be two separate checkboxes. And since then, we've been in discussions with the authority. They've published an updated guideline, and they are trying to set this as a part of their new position. They are providing some more clarifications on this. On the other hand, this is a subject to a court case, so there might be a court decision that will change the situation again. So this is again creating a concern between companies operating on the Czech market.
Jan, that was extremely interesting. Thank you very much for your overview on what's happening in Czech Republic and Slovakia. I would also like to thank all our listeners for joining us today, and in particular, I wish to meet all them again very, very soon together with you. Bye, everyone. Thank you.
Thank you.
Thank you.
It was a pleasure. Bye.
Bye-bye.